And yes, this is a little thing about pigs. No, I'm kidding. Happy New Year to you all, guys. I've been having a great little chat with our mate Brent down in Wellington, and he's just informed me of some very interesting stuff which kind of makes sense to me, and probably will make sense to a lot of what we may call lay people, or self-litigants, or self-representing, or pro se people. There's lots of different names for the same fucking thing. So here is the interesting piece of information. If you are self-representing in court and you have a witness, you can't cross-examine. I mean, you can, but the judge and the presiding officers don't have to give any fucking credence to it. You are not a member of the bar and therefore cannot cross-examine. Now, the courts should know this. It is the court's duty to inform self-representing litigants because they aren't members of the bar. They aren't familiar with the correct procedural ways of doing things. So, if you just go ahead and cross-examine, now, I'll give you a couple examples. With the $80 speeding ticket I did back in 2017 that I won, the only reason I won that, they withdrew with consent, is because the court itself failed in its duty to keep an accurate record of the trial. They lost the trial. Because it wasn't in the public's best interest to retrial a speeding ticket, the police had no option but to withdraw by consent. So that's why I won that one. Now, I also won the parking ticket in 2018 in Waitakere Court. The reason I won that, and yes, I did cross-examine myself, the parking warden on the stand. But again, all of that paid no part. What I did do is through submissions produce photographs showing the flaw. That is why I won, because I introduced evidence. I didn't testify myself. I never go on the stand and testify against myself or put myself in that position. So you must be given assistance of counsel to cross-examine. If the court doesn't do that, that is an abusive process straight away. If you, so for instance, we'll say we're doing a mock little thing here. I'm standing there as a self-representing litigant, challenging a speeding ticket, for instance, and they bring, first of all, they bring a witness up on the stand. Now, in New Zealand, under the Criminal Disclosure Act, Section 12(2)(a), you, as part of initial disclosure, are supposed to be supplied what is called a witness list. Now, they might supply and disclose your statements from all these sworn statements, in fact, that they, of the people they intend to call as witnesses. But such for like Tony's case, on the 9th of November, the police were given a Section 30 order. Section 30 order means the court ordered the police to supply Tony full disclosure within 30 days. Now, Tony did get a large bundle of disclosure by the 12th, including the CCTV footage. CCTV footage came with a copyright notice from Auckland Airport saying they still own the footage and it's not to be copied or reproduced. Naughty, naughty New Zealand police prosecutions. You copied that and you gave it to someone else who now has a copy of it. Guess what's going to be released in due course? And yet it's a great footage showing Cherie here, that psycho little senior constable, attacking Tony for filming him. Great, it's much better angle, and I've synchronised it all too, so you can actually hear what's being said along with the footage from the CCTV. But like I say, in due course that will be released. It's going to be a long way away because the call-over hearing's not until May of this year, just to get another date to have the hearing. But in that case, the police have breached the Section 30 order. There's no witness list. So, guess what's going to happen when witnesses get called up? Objection. We weren't informed of any witnesses. There was no witness list. Why did the police breach the Section 30 order and not supply it? Section 147, Criminal Procedure Act 2011, Section 147, application for withdrawal or dismissal. It's that simple. They're going to have to dismiss it. Now, if they do choose to bring up all these witnesses, and Tony being a self-representing litigant and having me as a lay assistant to help him, there's going to be an objection straight away when witnesses come up. And this will happen on other cases too that I'm dealing with, because they tend to not give a fuck about following the procedures. They abuse the process every fucking day, and the police haven't supplied witness lists on a number of cases that I'm helping. By not supplying a witness list, we have no idea if there being any witnesses, do we? So when a witness shows up, we haven't been given adequate time or anything beforehand to know about it. But back onto the member of bar cross-examining. So what you do is you're standing there, a witness gets called up onto the stand, you object. You object straight away and ask the court, or the judge, or the presiding officer, or the fuckwit in the black robe sitting up there higher than thou, ask that prick, hey, I believe the court must adjourn. Because as the court may well be aware that as a self-representing litigant, we have no option to cross-examine and require legal counsel for assistance to cross-examine the witness. Now, the court's got two options there. You can either ask for a Section 147 dismissal straight away because you haven't been supplied the witness list, so they've breached the abusive process there, they've breached the procedural rules, there's been procedural flaws in the proceedings of that case. And then if the court chooses to ignore your request for an adjournment, for the court to appoint legal counsel, this is not counsel you have to pay for. No, you have free assistance of legal counsel. Legal aid isn't needed because the court should be assigning legal counsel for any self-representing litigant that has to cross-examine a witness, but they don't. So the court has already committed an abusive process by then allowing that to happen. If you still, as a self-representing litigant, are left to cross-examine a witness, God knows, it's pot luck. But the judge and the judicial officers do not have to listen to you one bit, because you're not a member of the bar and have no ability to cross-examine any witness on the stand. So if the court doesn't want to adjourn, you should point out that that would create a breach of natural justice, because under natural justice you have a right to free representation and they must follow those procedures. So, Your Honour, I believe we need to adjourn so the court can assign legal counsel to assist in cross-examination. If the court goes right ahead, Your Honour, is the court aware that would be creating a breach of natural justice? And what does a breach of natural justice commit? It creates a miscarriage of justice, which you can then go ahead and appeal in a higher jurisdiction. It's that simple, guys. So don't get tricked into thinking that as a self-representing litigant, like I have been, and I was absolutely gobsmacked, but so many self-representing litigants out there, Amanda, you know what I'm talking about, who have done an awesome job cross-examining people on the stands and then end up losing. Well, perhaps that's why, because judges do not have to listen to you if you are not a member of the bar and cross-examining. It means nothing. All right? So that's trying to change the game, and you can do all of this by way of memorandum to the court, memorandum to the judge in regards to that matter, you know, and see how things go. So really handy information if you're going to self-represent yourself as a self-representing litigant and you are coming up against a witness that needs cross-examining. 1, don't do it yourself. 2, request an adjournment so then legal counsel by the court can be assigned to assist you in cross-examination. And if that all works, cool. If you don't get a witness list, object straight away because they've breached the procedures. You weren't informed that it's going to be a witness. You might have assumed they may have said, oh yes, Your Honour, we've got possibly 3 or 4 witnesses during the hearing, but nothing's in writing, and that's a breach of 12.2a of the Criminal Disclosure Act. Alright, I hope this helps you guys. I'm going to keep it short. I've got a few more very interesting videos coming up. And I was just watching the laughing auditor over in England saying that you can't record in courtrooms. Well, if that's the case, I'm a very naughty boy, because for the last 10 years, I've recorded many, many courtrooms. Okay? And it is not an offence to do so. They will revert to civil trespass to get you off the property. And even if you do get trespassed, if you have an upcoming hearing to attend at a place where you've been trespassed, they're summoning you, they're inviting you back, which makes the trespass null and void. Also under the Trespass Act 1980, section 4, subsection 5b, I believe it is, even if you are trespassed from somewhere, in the cases of an emergency which relates to safety or concerns for yourself or a family member or your property, you can breach a trespass in those cases, in cases of emergency. Alright? This worked out really funny when I was trespassed from an emergency medical centre, which I then got them to rescind 5 days later because I pointed out I would only be there in cases of an emergency. Fuck you, trespass. But see, this is what companies over in New Zealand do to people that exercise their rights in a public place. Namely, I recorded the doctor not doing his job properly on my wife's broken knee. He didn't like that being released on YouTube. He didn't like the health and disability complaint made against him. So the medical centre tried trespassing myself and my wife 6 weeks after we go there for a consultation. And like I say, me and my wife, who had nothing to do with it, got those trespass notices rescinded some 5 days later, simply by contacting the board of trustees of the medical centre and showing them those points of fact and law. Now, the other little thing you guys must always note is that legislation is not set in stone. Legislation are only guidelines. Okay? It's up to the individual judge interpreting those guidelines. But law is only, well, legislation is only a guideline. Okay? It's real simple to try and think that legislation means more, but it isn't. What's more powerful than legislation is any document you make, making it an authority, i.e. putting it in as a footnote in your submissions, making it an authority, and then they do have to look at it. An authority, by the doctrine of principalities, I think it is, authorities have more power than guidelines of legislation. Anyway, guys, I hope that helps all you self-representing litigants out there. I do sometimes babble on. Shit happens. I hope you all have an interesting 2023. It's going to be an interesting one for me. I know I've got about 5 hearings to go to. Woohoo! And only one of them's for me. Anyway, guys, much love to yous. Happy New Year's. See ya.